Okay, good afternoon, everyone. Thank you for joining us for today's webinar, Strategies for Successful Debriefings for Government Contractors. I'm Robert Ruggieri, and I'm here today with my partner, Timothy Furin. We will be presenting the webinar today. Tim and I are both government contract attorneys, the law firm of Cohen, Seglias, Palace, Greenhall, and Furman. We also have Michelle Burnett with us. She is the Executive Director of the HubZone Contractors National Council. The webinar is being hosted by Cohen Seglias in conjunction with the HubZone Contractors National Council. Cohen Seglias is a proud annual sponsor of the council, and we enjoy participating in its events and working with its members on government contracting issues, including those that are unique to HubZone contractors. And a special thank you does go out to Michelle for helping us put this webinar together and helping us get this content out to all of you. So before we move forward, I did just want to hand the mic over to Michelle and give her an opportunity to introduce herself and the council.
Thank you so much. I really appreciate you guys doing this, and I appreciate you being a part of our organization. You've been an amazing asset and assisted us in numerous initiatives, and we're lucky to have you. I wanted to inform the members that we will be reaching out to you here shortly in regards to a call to action with the sole sourcing legislation that has been passed through the House and is moving towards the Senate. It is HR 190, and the Senate is thinking about backpedaling on it. And if you're unfamiliar with it, HR 190 expands the sole sourcing cap to extend it to each individual option year, but I'll give you some additional information about that, so just be watching your emails. But I'm going to sit back, relax, and I'm going to enjoy this webinar. I'm really looking forward to it, and I think everybody's going to learn a lot, so thank you again. And I'll kick it back to you guys.
Okay, thank you, Michelle. So before we dive into the discussion on our topic today, debriefings, I do want to briefly introduce Tim and I and Cohen Seglias. Cohen Seglias is a full-service law firm with more than 70 lawyers and offices in 9 locations, including Washington, D.C., New York City, Philadelphia, Louisville, Kentucky, and Pittsburgh. Our clients operate in the United States, as well as internationally and across a variety of industries. Tim and I are partners in the firm's government contracts group, where we represent federal government prime and subcontractors in all types of contracting matters with federal agencies. We do have several attorneys, including Tim, who have previously worked for federal agencies, including the Army Corps of Engineers. This certainly gives us a unique understanding of the government's perspective and procedures. We represent government contractors of all sizes, from those participating in the SBA and VA's 8A, and the HubZone and VOSB and SDVOSB and WOSB and EWOSB programs, as well as larger, well-established corporations. Our clients also span a number of industries, many of which are in the construction industry, and they include a large number of companies based outside of the United States. We represent contractors basically throughout the life cycle of a government contract, from assisting clients with proposal preparation, contracts, teaming agreements, mentor-protege agreements, and joint venture agreements. We also assist clients with drafting and reviewing, negotiating contracts and modifications. We assist with the preparation and litigation of protests, REAs, and claims as well. And then finally, if necessary, litigation, arbitration, and mediation. So basically, if it involves government contracting, we have it covered for you. Please check our website, cohenseglias.com, to learn more about the firm and Tim and my specific experience. So, okay, that'll do it for the introduction. So let's get started with the discussion of our topic, debriefings. We are scheduled to go till about 1 o'clock today, and we plan and expect to finish up a few minutes early. So there'll certainly be time for questions and comments at the end.
You know, Bob, it's funny that Michelle mentioned some pending legislation for the House of Representatives, because we've seen a lot of recent movement with regards to bid protests and debriefings, really starting back in fiscal year 2016 with the National Defense Authorization Act. And a lot of folks out there may have heard of it, but in the 2016 National Defense Authorization Act, Congress directed the Department of Defense to stand up what's called the Section 809 panel to study federal acquisition, in particular bid protests and debriefings. And we've seen a lot of movement over the last 3 years with regards to bid protests and debriefings. In particular, we're going to talk about some enhanced DoD debriefing requirements that Congress has implemented. Of what's very interesting to me is that Section 809 panel just released Volume 3 of their report in January, which radically revamps the way that bid protest litigation is going to move forward. And so we can certainly touch on some of that. But what's interesting is why Congress is doing it. And if you look at any of those studies that have come out from the Section 809 panel or any of the industry groups that we're involved with, the American Bar Association, the certain committees that deal with the bid protests, you really see two things, and really two polar opposite positions. One is the government is very afraid that debriefings are going to go ahead and lead to more protests. And on the flip side, you see that the contractors are very interested in debriefings, not so that they can file a protest, but really so that they can get information on how to make themselves better. And if you look at some of the new enhancements that Congress has passed, what you're going to see is that a lot of that is geared towards getting information to contractors to reduce the number of bid protests and provide the information that contractors want to have. So I think this is a very relevant topic. It certainly is changing as we speak, and just thought I would mention that since Michelle mentioned some pending legislation.
Thanks, Tim. That's a good point. All right, so debriefings, they certainly can provide a great opportunity to government contractors, but they can also be a great source of frustration to both government contractors as well as government personnel. They are certainly an integral part of the government contracting process and an important tool that every contractor should use and have in their toolkit when bidding on government contracts. They certainly do provide opportunities to learn and obtain information about not only your own company, but the procuring agency and maybe even some information about your competitors. They provide you with an opportunity to really see how the procurement and source selection system works, or unfortunately doesn't work at times, and can give you or should give you confidence in the selection process and give you reason to protest an award if you don't feel that process was followed properly. Also, they could certainly provide you with a valuable marketing opportunity and face time with the agency. But in order to maximize these benefits that are available through a debriefing, you really do need to understand and identify what is strategically important to you and your company and what you can do to achieve that through your debriefing. And of course, it's going to vary with each procurement. And as we'll discuss throughout the webinar today, and you'll hear as a theme, preparation is really the key to a successful and useful debriefing. And that preparation includes having a good understanding of the specific goals for the debriefing for your company, and also knowing the solicitation, your proposal, and the applicable rules really inside and out. And we're going to cover all that today. So by the end of the webinar, we expect you'll be armed and prepared, certainly to get the most out of your debriefings. Now, the purpose of the briefings, or what should be the purpose of the briefings, I'll say, are listed here, and they, the briefings can and really should serve many purposes. In theory, debriefings are available to help the contractor learn, and this, from the government's point of view, the strengths and weaknesses and deficiencies in their proposal and understand the basis for the agency's decision, with the goal being to learn what can be improved upon for future procurements, and also learn what you did well and what should be carried through for the next procurement. Along those same lines, the debriefing gives you an opportunity to understand the evaluation process and the selection process and whether it was followed properly. And if that selection process was not followed properly, or if the agency didn't properly consider your proposal in the way it should have, the debriefing may uncover and help you understand possible protest grounds. You can and often should use the debriefing as a marketing opportunity for your company. This is a lesser thought purpose of debriefings, but it's an important one as it provides you with an opportunity to meet with the agency in person and promote your company. While you may not have won the contract at issue, you can still make a positive impression on the agency during the briefing. You'll have a captive audience during the debriefing, and you should use that opportunity to showcase your company's competence, its technical expertise and experience, and the good past performance you may have. All this with the intention of bolstering your reputation for future procurements. This is especially the case when you see additional contracting opportunities ahead, and or if you are trying to make inroads with this particular agency and you don't have a substantial amount of experience dealing with them. But the reality of the debriefings is often quite different, and which makes them, unfortunately, at times much less valuable and can result in missed opportunities. Often the stated purpose of the debriefing is at odds with what the parties' intentions are going into the debriefing, and that's unfortunate. From the government's point of view, they might simply be going into the debriefing looking to protest-proof their decision. And they do this by maybe providing as little information as possible rather than provide the offeror with information that will help it in the future and give it confidence that the selection process was proper. By trying to protest-proof or restrict the amount of information, they do the exact opposite, and it only leads to more protests. And protests that maybe wouldn't have been submitted or filed if the agency had approached the debriefing differently and with more of an open mind and open attitude. On the other hand, from the contractor's point of view, contractors often, unfortunately, think they're going into the briefing to argue with the agency to try to get it to change its mind. I'll tell you, this almost never happens, and it's usually counterproductive. It puts everyone on the defensive and prevents you from obtaining valuable information, which in some cases could lead to a successful protest and eventual award to you. But if you go in there with the wrong mindset and the wrong attitude and being argumentative, you're less likely to get the information that you need. And while the debriefing can be a valuable tool for understanding whether you might have good grounds for a protest, it shouldn't be the only thing or the only reason to go into a debriefing. It shouldn't be simply considered a fishing expedition for a protest. By doing that, you lose focus and you might forget really why you're there, and that's to obtain valuable information. And if this attitude comes across to the agency that you're simply there to see if you can protest or gain information from a protest, again, they're likely going to get defensive and limit the flow of valuable information. So really, what the key here is, and the approach to the briefing should be with an open mind. You should encourage open conversation with the agency, and really that gives you your best chance to obtain as much information as possible. And while you certainly can't control the mindset that the agency has going into it, the more that you show that you're there to learn and listen and not argue or set up a protest, the more they will open up and give you the information that you might need for that eventual protest if that's really the best option. The expression that you get more bees with honey than with vinegar definitely applies to debriefings. So when are debriefings required? Debriefings are required in connection with any contract awarded under FAR Part 15, Contract by Negotiation, and they're also required in connection with any order exceeding $5.5 million under an IDIQ contract, under FAR 16.505B. But, and this is an important but, they're only going to be required if a written request for debriefing is received timely by the agency after your notification of exclusion from the competition under FAR 15.505 or notification of contract award. If you don't timely submit the request, you're not entitled to a debriefing. And that doesn't mean that the agency won't still give you one, and they often do. Specifically, the FAR 15.506A4 states that untimely debriefing requests may be accommodated. And that's great, especially if you miss the deadline. But you got to be careful, because if you don't timely request that debriefing, it is no longer a required debriefing. And you can't see me, but I'm putting that required in air quotes because the fact that it's required debriefing, or whether it's not a required debriefing, affects your protest rights. Generally, the clock for filing a protest is going to start at the conclusion of your debriefing, but only if that debriefing is a required debriefing. If the debriefing wasn't required, the protest clock isn't suspended until the briefing's over. Rather, and instead, it likely started back when you received the notice of award or notice of exclusion. So that's very important to keep in mind. And this was just the subject of a GAO protest a few months back, where the disappointed offeror did not timely request the debriefing, but the agency provided one anyway. And a few weeks after, but the briefing wasn't provided for a few weeks after the award. The offeror then filed a protest, which it thought was timely because it was within 10 days after the briefing, but that protest was kicked out for not being timely because it was not filed within 10 days of a required debriefing and was filed more than 10 days after the notice of award. So that's an important lesson to remember when you think about timing and whether debriefings are required or not. So when are debriefings not required? There's a number of them. Under FAR Part 8 of the Federal Supply Schedule, acquisitions under the Federal Supply Schedule procedures or sources of supply procurements, or GSA schedules. They're also not required for commercial items procurements under FAR Part 12, simplified acquisitions pursuant to FAR Part 13, and sealed bidding acquisitions under FAR Part 14. And also, of course, as we just talked about, they are not required if not timely requested. Like I said, the agency may give you one, but remember that doesn't affect your protest rights. But I do want to point out why we're on the slide and talking about when debriefings are not required, that where an award is based upon factors other than price alone, the agency is required to provide, upon request, a brief explanation of the basis for an award decision under FAR Part 8 and 13. You should request these explanations just like you would with the briefings, as they could contain valuable information. But remember, these brief explanations don't have the same impact as the debriefing, and that's been demonstrated often in GAO protest decisions. So don't confuse these brief explanations under FAR Part 8 and Part 13 for a debriefing. They do not impact the timing of your protest. And it doesn't matter what the agency calls it. They still might call it a protest, but if it's not under FAR Part 15 or 16.5 for task order deliveries, it's not a debriefing and it's not going to affect your protest rights. It doesn't suspend the timing for a protest. Types of debriefings. There are two types of debriefings. There's a pre-award debriefing, which is going to be conducted pursuant to FAR Part 15.505, and a post-award debriefing conducted pursuant to FAR 15.506. The pre-award debriefing is offered and occurs after offerors learn that they are eliminated from competition, but before award. This is usually upon receipt of a notice of exclusion from the competitive range. And the post-award debriefing is offered and occurs after the notices of award and notices to unsuccessful offerors are made. It's important to remember that each type of debriefing has different rules for timing and what types of information is available. Tim's going to get into the key differences and similarities in these debriefings in just a few moments. Should you request a debriefing? That's probably the easiest thing we'll talk about today, and hopefully the one thing you remember, and it's yes. You should always, to the maximum extent possible and practical, request and participate in a debriefing. And that goes for whether you're an unsuccessful offeror or an awardee. I think we've covered extensively why and the many reasons why a disappointed or unsuccessful offeror should request a debriefing. Frankly, it's just too valuable an opportunity to waste. There's much to be learned and gained from debriefings. Again, you gain information not only about yourself, about the agency, about your competitors, and it's remember, it's a good marketing opportunity. But debriefings are also valuable to awardees. First, you obviously will get to learn more about the strengths and weaknesses of your proposal, and you can also learn, of course, on how to improve your proposal, find out what the agency liked, and so you can make sure that you continue those throughout for procurements in the future. But also, and as an awardee, and this is an important part, you have a vested interest in protecting that award and ensuring that that agency's decision is not disturbed or overturned by later protests by other competitors. And one way to do this is to help the agency prepare for for debriefings with those unsuccessful offerors by having your debriefing first. It's perfectly acceptable to request that the agency debrief you as an awardee before debriefing the others. You should certainly request that next time you're an awardee. And this debriefing is going to give you the opportunity to ask some difficult questions that the unsuccessful offerors might ask, and if they hear certain agency responses, it might lead them to think that something wasn't done properly and make them think that they have a grounds for protest. So it kind of gives a good dry run for the agency to prepare for debriefing of some less friendly offerors that might go in there looking for grounds for protest. If you could get in there first, meet with the agency, discuss the process, maybe particularly how the trade-off decision was made, and help them make sure their answers are clear, so other offerors won't think that they have a good protest ground. And also, as the awardee, it gives you a good chance to grow your relationship with the agency prior to kicking off the project. Notices of debriefings. There are different notices for the two different types of debriefings. The opportunities for the two types of debriefings come about after receiving one of the two types of notices you receive after submitting your proposal for a FAR Part 15 procurement. There's the pre-award. The government is required to notify offerors of their exclusion from the competitive range or otherwise from their elimination from the competition before a contract award, and that's under FAR 15.503. In the post-award situation, the government is going to send a written notification of award to both the awardee under 15.504 and to the disappointed offerors under 15.504 as well. This award notice shall include a number of things: the number of offers that were solicited, the number of proposals received, the name and addresses of the awardees, the items and quantities, and slated unit prices for each award, and in general terms, the reason the offeror's proposal was not accepted. These notices are important because they trigger the time to request a debriefing, which in turn may trigger time for a protest. And the notices also give you a sneak peek into the evaluation and should be carefully reviewed before the debriefing. And they may tip you off as to whether you have a legitimate basis to protest that should be examined and explored more during the debriefing. So at this point, I'm going to turn it over to Tim, who's going to discuss the timing of protest and the different types of information that you can obtain during your debriefings.
Thanks, Bob. So, like Bob said, the majority of what we're talking about is focused on FAR Part 15, and the key to FAR Part 15 is the required debriefing. So we know under FAR Part 15, we have a debriefing is really an opportunity for a contractor to better understand the basis for an agency source selection decision. And in addition to better understanding the agency source selection decision, it's also an opportunity to really determine whether or not you want to file a bid protest. And if we start talking about bid protests, we can look at, there are really three different forms where bid protests can be filed. One is with the agency, and agency level protests are pretty easy and pretty basic. I am not a big fan personally of agency level protests unless there's an issue out there that is glaringly obvious, because for all intents and purposes, the disappointed offeror is filing a bid protest with the contracting officer who just denied him or her the award. And generally, at least based on my experience both with the government and in private practice, agency level protests are not very effective unless the issue is very, very obvious. The second form where bid protests can be filed is the GAO. And last year in the GAO, there were 2,607 bid protests filed. 44% of those were either sustained or the government took corrective action. So at the GAO, there's about a 50% likelihood of success. It really ranges between, over the last 5 years, 43 and 47%. And so the majority of bid protest litigation is done at the GAO because it's cost effective and there's a higher likelihood of success. So we have the agency level protests, we have the GAO protests, and then offerors can also protest to the Court of Federal Claims. The Court of Federal Claims is very expensive to protest to. and the likelihood of success is really dependent upon which judge you draw. The judges don't follow each other's precedent. So why am I talking about bid protests? Well, as Bobby noted earlier, when we start talking about debriefings, the key terminology with regards to debriefing is required. When are debriefings required? In a lot of cases, you'll have government agencies will give a debriefing, but it's not a required debriefing. And the required debriefing is the term of art that assists with a disappointed offeror's ability to file a bid protest. So let's jump back and say we're at the GAO. There are two different timeliness rules with regards to the GAO. The first is whether or not we are timely with regards to jurisdiction, meaning can we get our protest before the GAO? The second is, are we timely with regards to the automatic stay? And both of those have two different timelines. For pre-award protests, the GAO will have jurisdiction if the bid protest is filed prior to the deadline for submission of proposals. And the automatic stay, the stay is automatic upon notice of the protest. For post-award protests, we start looking at really the two different timelines. The first, to get into the GAO, you have to file a bid protest within 10 days of when you knew or should have known of the issue that's going to be before the GAO. If we request a debriefing and the debriefing is required, that kind of changes our timeline a little bit with regards to the automatic stay. If the protest is filed within 5 days of a requested and required debriefing, we automatically get the stay. If not, we have to file for the stay within 10 days. So again, I go back to the key terminology here is a required debriefing because it drives all different kinds of issues with regards to our ability to, number one, file a protest, and number two, get the automatic stay in the protest. So when we're looking at our pre-award protests, the timing of the request is critical. For pre-award protests, we have to file a requested debriefing within 3 calendar days of receiving notice of exclusion from the competitive range or from the competition. If we request a debriefing within those 3 calendar days, then it's a required debriefing, and we've preserved our right to not only file an appeal at the GAO, but also to seek the performance stay. For post-award debriefings, for a debriefing to be required, we have to request it within 3 calendar days of receipt of notice that we're an unsuccessful offeror. And if we request that within 3 calendar days, then that debriefing is required. And again, we preserve our right not only to file a protest at the GAO, but to seek a performance stay, which we're going to talk a little bit more about later on in the presentation. So oftentimes you'll see the government is very strategic about how they do this because they know that the clock starts running upon notice. So I've seen it, especially with the last several bid protests that I've done, that they will give you notice of award on a Friday evening, right before close of business. Sometimes the email won't come out until Saturday. Anything received after Friday close of business, or if you were to receive a Saturday notice, is considered received on the next business day. And so your time would start running on Monday, and you would then have 3 calendar days to request a debriefing. Oftentimes you can do this well in advance. Typically you want to we're going to talk about some of the strategies for requesting a debriefing, but really in most cases you know that you're going to request a debriefing, and you probably have a game plan put ahead. So usually the notice with regards to debriefings is not an issue. What becomes an issue is how do you request the debriefing? To be a required debriefing, it must be requested in writing. Email is okay. What we typically advise clients to do is to go ahead and prepare some kind of letter on their letterhead and to request a debriefing in a letter and attach that to an email. We also generally advise clients to go ahead and send that via certified mail so that the government receives it not only via email, but also there's a record that they received it via certified mail. When I do a debriefing request via email, I always try to make sure that we send it to the contracting officer and the contracting officer's representative, and we'll send that with different delivery options where we can at least demonstrate to the GAO that we requested the debriefing timely. We sent it to the government. It was delivered to the government with a return receipt via email. And then I also always try to do the read receipts so we can demonstrate that the government read our email. Finally, in the email body itself, what I always try to do is request that the contracting officer and the contracting officer's representative acknowledge receipt of the email and the attached letter. And typically that protects you and preserves your right to move forward with the debriefing. So the government controls when debriefings are held. If you look at the FAR, what the FAR says is that they should be held within 5 days after the request to the maximum extent possible. In most cases, the government is able and wants to comply with this particular FAR provision, although I have been involved in cases of a particularly complex nature where the government will request more time to hold the debriefing. But in most cases, they're typically held within 5 days. And again, when you're dealing with the debriefings, it's really a game of strategy for the government in some cases, because they know your protest clock starts running from the time that the debriefing concludes. So oftentimes you'll see the government will want to hold a debriefing on a Friday or some time that's more advantageous to the government and less advantageous to the contractor with regards to filing a bid protest. The key here, and I want to make sure everybody understands this, is when we start getting into bid protests that are coming out of debriefings, and I understand that that's not the primary purpose of a debriefing, the key is the date offered by the government. Okay, so oftentimes, and I've seen this happen with several clients here in private practice, and I saw it happen a lot when I worked for the government, is the government will offer a date, and the date does not work for the contractor. The contractor will then go ahead and say, hey, I can't do it this Friday, but I can do it next Friday. The government will say, great, we'll hold your debriefing next Friday. They'll hold the debriefing the following Friday, and then the contractor will go ahead and try to file a bid protest. Your timeline starts running from the date that the government offers the debriefing. So to the maximum extent possible, when you're dealing with the timings of debriefings, if the government offers a date, you should try to have the debriefing on that date or as close to that date as possible, because I've seen a lot of contractors get burned by this. In cases that deal with pre-award debriefings, the agency can elect to delay that until after the award decision is made, if it's in the best interest of the government. It shouldn't be delayed beyond time for post-award debriefings. And if it is delayed by the government until the post-award debriefing, the information that the government is required to provide is the same that it would be required to provide to any other offeror that is asking for a post-award debriefing. So essentially, your pre-award debriefing would become a post-award debriefing. If you timely requested it, it would still be required. You would get some additional information, and then you'd be able to file your bid protest, alleging any issues or errors with regards to the solicitation. So how are debriefings conducted? I always advise my clients to request an in-person debriefing. I have found that you are able to better communicate your position and engage in conversation that will provide you more information if you do so in person. It's really just human nature. If we sit down at a table and we start talking about the different issues, I'm generally going to learn more about you. You're generally going to learn more about me, and really that's what we're here for. We're here to better understand the basis for an agency source selection decision. And what we do with that information, whether we file a bid protest or not, or whether we just take that information back and figure out how to become a better contractor, generally in most cases, face-to-face is always better. However, the government really gets to control that, and it's within the discretion of the contracting officer. A contracting officer can conduct a debriefing over the telephone. They can do it via video conference, in person, or in writing. You should always express your preference for what you want, but at the end of the day, the discretion lies with the contracting officer. And so what we've seen recently in most agencies, now the Air Force is a little bit different, but in most agencies, when we look at what Congress recently passed with regards to their enhanced debriefing requirements for DoD procurements, you see the agencies have really been sending out a PowerPoint slide that provides little information. So Congress's new legislation has done the exact opposite, because agencies are very wary of bid protests, and instead of providing more opportunities for disappointed offerors to get information, contracting officers are providing less information in the initial debriefing. So we're seeing a lot of cases where, again, the Air Force is a little bit of an anomaly, but a lot of cases where the agency is providing information in a PowerPoint slide that only hits the required information that's required by the FAR. And what the agency is expecting then is follow-up questions pursuant to the enhanced DoD debriefing rules. So be very cognizant or be very leery of any debriefing that you get in writing, because it's not really going to be responsive to your needs or provide you with the information in most cases that you want or need. All right, so what are you entitled to learn during a pre-award debriefing? This information comes directly from the FAR, and so when we're talking about pre-award, this is where an offeror has been eliminated from the competitive range or eliminated from the competition. And at that point in time, you're entitled to know the agency's evaluation of the significant elements in your proposal. So how they've evaluated you and what led to them eliminating you from the competitive range. You're also required to be provided a summary of the rationale for eliminating you from the competition. And you're entitled to reasonable responses to relevant questions about whether the source selection procedures were followed. And we're going to talk about this a little bit more in detail later as we start going through some of the strategies to do this. But I always advise my clients to submit questions in advance of a debriefing, and will help prepare questions related to FAR requirements, number one, but two, other issues that we can provide to the contracting agency in advance of the debriefing, so that they have an opportunity to understand where we're coming from and to prepare responses that are useful to you as a business owner. So this is what you're entitled to pre-award. This is what you're not entitled to learn pre-award. You're not entitled to know the number of offerors, the identity of the other offerors, the content of their proposals, the rankings of the offerors, or how the other offerors were evaluated. There's also certain information that's prohibited by FAR 15506, which deals with post-award debriefings and largely deals with proprietary information. There's also other information that the government's prohibited from providing because it's exempt from disclosure under the Freedom of Information Act. When we start dealing with post-award debriefings, this is the information that you're entitled to learn. You're entitled to know the government's evaluation of the significant weaknesses and or deficiencies in your proposal. And this is key. There's a big difference between a weakness and a significant weakness. And when we start talking about protest grounds, those differences become very, very important, especially when you're dealing with the FAR Part 15 negotiated procurement and whether or not discussions were held. And we'll touch on that in a second. You're also entitled to know the overall evaluated cost or price and technical ratings of the successful offeror and the debriefed offeror and the past performance information associated with that. I typically advise my clients to not only ask for the technical ratings of the successful offeror, but to also ask for the technical ratings of all the offerors. The government's not required to provide it. In some cases, they do provide it, and it lets you make an assessment on whether or not you're eligible. You would regain the opportunity to recompete in the best value procurement. And again, that's an issue that'll become critical to whether or not you can assert your bid protest rights. You're entitled to an overall ranking of all the offerors. This becomes particularly important when you're dealing with lowest price, technically acceptable procurements. You may be, if you are number 7, if you learn that you were the 7th lowest price during the lowest price technically acceptable protest, you would have to not only be able to protest and knock out the awardee, but you'd also have to be able to knock out the other 5 companies that were in front of you. So this is critically important when you start talking about LPTA procurements. You're entitled to a summary of the rationale for award. This should mirror what's in the source selection decision document. Oftentimes it doesn't. The government will provide a very, very generic rationale for the award. And I found that this particular FAR provision isn't particularly helpful. And again, you're entitled to reasonable responses to relevant questions about whether the proper source selection procedures were followed. With regards to this, when you're dealing with a lowest price technically acceptable procurement, there's been recent updates and changes to the law, and the government has to do certain things before they can decide to do an LPTA procurement. I always like to ask those questions whether they've done those certain things, because in most cases the answer is no, because they don't know that that exists. And so again, you can craft certain questions to help gain that information that's vital to you as a contractor. There are also certain things you're not entitled to learn during a post-award debriefing. The government's not going to do a point-by-point comparison of the debriefed offeror's proposal with your proposal. And I've seen a lot of times when we've provided written questions, the government will cite to this and say, we're not allowed to do a point-by-point comparison. And then you have to explain to them, that's not what we're asking you to do. We're just asking for certain information. You're not entitled to information prohibited from release by FOIA. Again, that's trade secrets, privileged confidential information, those types of things. And you're not entitled to know the names of individuals providing past performance information about the debriefed offerors. And that's to ensure that folks that provide past performance information are free to do so without any kind of repercussion. I think Bob's going to go ahead and talk to you now a little bit about how to prepare for a debriefing, and I will be back to comment in a few seconds.
Okay, thanks, Tim. Sorry, just getting up to the right slide. So, how to prepare for debriefing. And this is important because typically you're not going to have much time to prepare for the debriefing. And often there's a lot to be done to get ready to effectively participate and get the most out of your debriefing. So you're going to need to act quickly after receiving one of those notices we talked about earlier. And it's often a good idea to kind of put a lot of thought together and a team together, maybe even before receiving those notices, and have a plan that you can put into action upon receiving those debriefing notices. First, you need to look at the debriefing strategically. Really, we talked about this before, but what are you trying to get out of the debriefing? Are you just looking for information on how to improve for the next time, or do you feel confident in a basis to protest and that you're looking to confirm that basis? Or are you more focused on the opportunity to just meet with the agency and market your company and establish a relationship? So, whatever your goal is should really guide your preparation. Generally, you're going to want to carefully review the applicable FAR provisions that we've mentioned, primarily FAR sections 15.505 and 15.506. It's also a good idea to maybe even bring copies of those provisions, of those sections, so you can refer to them and the list of information that you're entitled to, and show those sections to the agency if necessary. Also, you want to make sure you review the RFP carefully, especially the RFP's evaluation criteria. That way, you can make sure that it was followed properly when you learn and hear information during the debriefing. Another thing that's important, Tim touched on this, is if discussions were held, you certainly want to familiarize yourself with the issues that were covered in those prior discussions. Were significant weaknesses and deficiencies raised in those discussions? You want to check that and compare that to the reasons why you were not awarded, you were eliminated from competition or were not awarded the contract. We just successfully litigated a protest a few weeks ago where a discussion letter did not identify specific weaknesses, which the agency later used as the same basis for a negative evaluation and it prevented our client from receiving one of a MATOC award. And had that issue and had that weakness, which really was a significant weakness because it was something that led them not to get the award, had that issue been raised in the discussion letter, our client would have easily been able to correct that issue and increased its rating, and therefore would have had a chance for an award. So those make sure you take a look and review those discussion letters because they're important as well. You certainly want to review the notice to unsuccessful offerors and of award because they do provide you a little sneak peek into the evaluation and see if you want to see if they raise any questions going into the debriefing, questions that you want to explore and investigate more thoroughly. It's always a good idea to prepare a chart, including a column for each evaluation criteria, so you could go through them systematically to hear from the agency on each factor, and make sure they evaluated each factor in the method that is identified in the RFP. You want to prepare a reasonable number of questions in advance if you can. Tim's going to go over some questions that will be generally good to ask during the debriefing. But if you think of those how they specifically apply to you and your debriefing, it's good to kind of write them down in advance beforehand. You certainly, if you can, prepare with a government contracts attorney, get their point of view on the notice, on the reasons for not being successful offeror, and they could also help you with some specific questions to help guide you and get the most out of your debriefing. As we talked about, it could be a marketing opportunity. So think about what your marketing pitch and how you can present your company in the best light to the evaluators for future procurements. And also, if you have time, conduct a dry run. Or at least have a meeting with the group that's going to be attending, and get ready, review the questions with everyone, and then that'll help you be prepared for your debriefing, certainly. Who should attend? It's an important question. You want to make sure you have the right people at the debriefing, people that can help you get the most out of it and ask good follow-up questions. And so at the very outset, you want to make sure you have someone that's familiar with the RFP and your proposal. This is going to allow you to ask meaningful questions and follow-up questions after you hear the agency's evaluation and their comments. It's also critical to have someone familiar with the regulations, so you know what information you're entitled to learn and make sure you get it. That's another reason why you may want to bring those FAR provisions as well. Also, make sure you have someone the person that's going to be responsible for the decision to protest. You want them to be there because the person that's making that decision, you want them to hear the information firsthand and be able to have their questions answered that they feel are important for that protest decision. Do you bring a lawyer? Probably not. We generally recommend that lawyers not participate in the briefing. Certainly, it's important to consult with them beforehand. We recommend preparing with your lawyer, but not necessarily bringing them or having them participate on the call. It's true. It's unfortunate, but it's true. Lawyers can bring a lawyer. Having them involved can send a wrong message to the government and shield the discussion. And this doesn't change even if the government's going to have their lawyer there. But it does change, and our recommendation is probably going to be different if you are the awardee and you expect a protest. Remember, if you are the awardee, the protest is an opportunity to kind of get ready the debriefing is an opportunity to kind of get ready for potential protest and work with the agency to make sure that their debriefings of the unsuccessful offerors support the decision in a way that isn't going to lead to any kind of suspicion or lack of confidence in their decision. So in that case, it might be a good idea to bring your attorney to assist in gathering information that's going to be helpful in defending against a protest. How should you participate in a debriefing? And it's important to remember that your goal is to obtain information. So when you think about how you participate, remember that's your goal. Obtain as much information as possible, whether it's for future procurements or whether it's for a protest. Your goal is how do I act? How do I participate in a way that's going to get me as much information, much useful information as I can? And remember, as we said before, honey, not vinegar. Be polite. Don't be argumentative. If you take that vinegar approach, the government's likely going to shut down and provide you with very little information. They're not going to change their minds. Certainly not after the briefing, and that's why if you feel you have get all the information you can, and if you feel you have a strong basis to protest, that's when you file the protest. Let your lawyers do the arguing later. Avoid antagonist remarks. Don't use the word protest. Don't suggest that a protest might be coming down the pike. And remember, listening is the most important function. You're there first and foremost to obtain that information, and second, to promote your company for future procurements. It's always a good idea, and we recommend to our clients designate 1 or 2 people to take notes so they can focus specifically on writing things down, and the others to be the speakers so they could be, and these are people that may be that are better on their feet, they can ask better follow-up questions, and so forth. Another thing we certainly recommend is stay for the entire debriefing. Don't walk out, don't end it prematurely. No matter how frustrating it is or how useless you might find it, you never know what's going to come out. Sometimes the last thing or last couple things said at the briefing are the most important and most valuable. So don't end it early. Don't walk out. Don't get frustrated. And more importantly, if you walk out early, it could negatively impact your protest rights. There was a case, another GO protest decision, a recent one where 2 offerors walked out of the debriefing early. They subsequently filed a protest, but the protest was dismissed on the basis that they left the debriefing early and they could have obtained information and discussed a resolution on the protested issues during that debriefing, which they cut short. This is certainly a bit extreme, but it's something you should remember and keep in mind when, even if the debriefing's not going well, stick through it, get whatever you can out of it, and then go forward from there. One other thing, inadequate debriefings are generally not a valid ground for protest. So even if you think that you're not getting all the information you're required to get during the debriefing that's listed in the FAR, that in itself is not a ground for protest, but it could lower the hurdle to proceed with a protest. So if you file a protest and it doesn't have the amount of detail that the GO generally sees, and the agency tries to file a motion to dismiss your protest for lack of detail, you certainly would have a good argument that, well, of course we couldn't provide that kind of detail normally required because the debriefing was inadequate. So with that, I'll pass it on to Tim, who's going to talk about the types of questions you should think of asking during the debriefing.
Right. So in addition to the questions that are required under the FAR, I always include those in the questions that I want to answer, just because the government oftentimes doesn't respond to those. But I certainly would include those right up front. Please provide the information that you're required to provide in accordance with FAR Part 15506. And then I'd like to ask some other questions. And the very first thing that everybody really wants to know is what could we have done different? How could we have been better? And I think that helps businesses grow as businesses, and it helps the agency explain the rationale for their source selection decision. The second thing I always like to do is review the agency's math. Make sure that what they've put in their source selection decision document, or the information they share with you from their source selection decision document, actually adds up. If we were rated excellent across the board in everything, for every factor and sub-factor, how do we get an overall rating of acceptable? So we just want to do the math and make sure that it's correct, because people do make mistakes. I always ask, or advise clients to ask that they describe the evaluation process that was used. And again, when you look at the evaluation process that the government used, you want to make sure that it matches up with what's in the RFP and that it was followed. The government, when we deal with any of these procurements, gets to make the rules, and they get to do that in Section M and L of the request for proposals. But then they have to follow the rules. And we were just very, very successful on a $54 million construction project, where the government said they were going to evaluate using certain terms: outstanding, excellent, acceptable. And then when we got the evaluation, they actually used numbers 1, 2, 3, and 4, and that was a valid ground for protest. So ask the agency to describe the evaluation, the process that was used, and make sure it lines up with what's in the RFP. And then you always want to ask the agency to identify strengths and weaknesses and deficiencies in the proposal for each factor and sub-factor. We kind of touched on this a little bit, but if the agency is going to go ahead and do a procurement that involves discussions, they are required to provide you and identify your strengths and weaknesses. And oftentimes, they'll do that during the discussion period, and then if you ask about it during the debriefing, they will identify additional weaknesses that they didn't previously tell you about during the discussions, and because they didn't previously tell you about them during the discussions were not meaningful, and it was not a level playing field with all the other competitors, so you have a good grounds for protest. So again, some of these questions are how do we get better? What we want to better understand the basis of the agency source selection decision. But some of the questions that we suggest you ask are also strategic to help better prepare yourselves for a bid protest in case you have to do that. Other things you want to know are were you compliant with the technical requirements? Were there any requirements in the RFP that you failed to meet? Were enhancements considered, particularly with regard to the other offerors' proposals? Did they consider things that weren't in the RFP that made the other offerors' proposal better? And again, this is a strategic question. If they consider information that you weren't required to provide, that can be problematic for the government. Did responses address evaluation notices during the discussions? You asked us certain questions. Did we provide answers to those questions? And again, that's a strategic question. Was a cost realism analysis used? This gets to be a little complex, but there are really two different ways you evaluate cost or price. One is was the cost reasonable, and the government's required to do that every single time. Reasonable means does it make sense for the government to pay this much? Realistic or cost realism means can the company actually do it for that price? And the government's required to evaluate cost reasonableness in every procurement. They're not required to evaluate cost realism in every procurement, but they often say they will, and they often do it wrong. So if they do a cost realism analysis, it can be a fertile ground for a bid protest. Did the agency prepare an independent government estimate? And this is key if they're going to go ahead and do that analysis. We always want to know how past performance was evaluated. You want to identify any information that's not contained in the proposal that was used by evaluators. Again, that's a strategic question. And then finally, you want to ask what was missing and what could be improved upon. Again, I always recommend that you send questions in advance. It gives the government an opportunity to see where you're coming from. I was very successful on a recent procurement with doing debriefing questions to not only gain information for our client, but to demonstrate where the government failed in their evaluation of the proposal, and we were able to get the government to take corrective action based on our debriefing questions without actually having to file a bid protest. Okay, timing is critical, and we're coming up near the end time of the webinar, so we'll be pretty quick here. We talked about timing with regards to your protest rights. Your debriefing concludes at the end of the session, and your protest time or clock starts running from the conclusion of the debriefing. Do not think that the government has extended the debriefing unless they've made a clear indication in writing. And asking additional debriefing questions does not extend your protest deadlines, even if the government answers them. Once the in-person debriefing is concluded, remember I told you Congress kind of changed the rules here for DoD debriefings. Once the in-person debriefing is concluded on a DoD procurement, the Congress has provided a disappointed offeror additional rights. They've done that to reduce the number of protests in an attempt to streamline the process. Okay, and what they're hopeful for is that unsuccessful offerors can submit questions based on the debriefing to the DoD agency, and then the agency will provide meaningful responses. All right, this went into effect on March 22nd of 2018. I don't expect that it's had any major impact with regards to the number of bid protests that were filed, although that is certainly the hope. What we've seen is the exact opposite, the agency providing less information initially. But if you're dealing with a DoD procurement, once your initial debriefing is done, you're allowed to submit additional questions within 2 business days after the debriefing. And then the government's got to respond within 5 business days after the receipt of those questions. And the debriefing is not concluded until the agency responds. So it gives you some additional time to ask some more questions, but this only applies to DoD debriefings. So what do we do after the debriefing is concluded? Well, we want to go back and talk with your team and say, hey, this is what we did well, this is what we need to do better, this is how we improve ourselves. You probably want to consult with your government contracts attorney to see if there are any viable protest grounds. Consider the lessons learned and implement those in future proposals. And then really you want to consider whether a bid protest is a viable option for you. And, you know, we do a lot of webinars on bid protests, the cost-benefit analysis on whether or not a bid protest is in your best interest. And what I'm going to include as part of the slides that come out with this is a bid protest quick reference guide for you to take a look at and review. All right, so I'm going to turn this back over to you, Bobby, in a second here. So you know, the information that you're going to obtain in a debriefing is going to be critical to determining whether or not you're going to file a bid protest. And we kind of talked about the timelines with regards to the bid protest. But again, it's the debriefings are really all about getting information to learn how we can become better, and then determining whether or not we want to challenge the agency's source selection decision.
Okay, looks like we're coming in right on time. This went a few minutes longer than we expected, but I got the last slide, and then we'll get some questions if there are any. Looks like we might have one. So to conclude it, key takeaways. Important thing is, remember, what are your goals for the debriefing? That will guide you on how you prepare and how you participate. I said it a million times, I'll say it one more time, listen carefully. Also, don't only listen with your ears, but use your eyes. Read body language and the tone and attitude of the evaluators and the people giving their the debriefing. Gauge their level of confidence in the decision. This could help in the decision to make a protest. Make sure you submit the request for debriefing timely, quickly, and if the agency delays the debriefing or getting back to you on scheduling it, apply polite but firm pressure to get the debriefing done as soon as possible. Prepare your team thoroughly, including questions. Designate the speakers, designate note takers. Remember, learn as much as you can. Act professionally. Avoid confrontation. This is not the forum for it. Again, let your lawyers be the ones that do the battle for you. And afterwards, when it's over, debrief your team and your lawyers about what you learned. So that does it for our portion. I don't know if we have any questions.
Certainly, we could provide written responses to.
Yeah, I don't see any questions coming up. But if you have any questions or if you think of anything afterwards, you certainly could reach out to us via email or telephone call later. I did see one question that popped up earlier, but for some reason it's not coming up now. It was on whether you could protest a set-aside decision if you think that I think it was if the procurement was set for open competition, but really you believe it should be set aside. Yes, you certainly can. Keep in mind though that protest would have to be filed before all proposals are submitted. There's a famous case, the Blue and Gold Fleet decision, where it says you can't sit on your rights and wait to see if you get an award and then file a protest later for something that you knew about beforehand. So that's certainly something to think of, but it could be a legitimate protest grounds if you believe that a procurement should have been, but wasn't set aside for small business.
Michelle, I have one question. Any way that a lot of with the contract bundling and the size of these contracts getting larger and larger, if for companies, like if they were to set aside or if it were kind of being positioned that it was almost exclusive for small businesses based on the way that it was written, what recourse or, you know, in your experience, do you think that this is something that small businesses should be, you know, seeking support of? Because in case you guys don't know, they do specialize in construction, and I know a lot of small businesses have been really struggling with all this contract bundling with, you know, bonding capacity, and that the way they're soliciting these contracts while they're claiming is open for small businesses is almost excluding them based on the stringency of the requirements. So is that something that these companies could be considering protesting about? Does that make sense, or did I?
No, it absolutely does. What I hear you saying, I think, Michelle, is the government normally would set aside something for a small business, but the way that they're preparing their request for proposals or the project, it's almost impossible for small businesses to compete for them because they can't perform the work. It's outside the scope of what they're capable of performing. Is that fair?
Mm-hmm. Yes.
So certainly any case like that is going to have to be looked at on a case-by-case basis. It's because it's going to be very, very fact-specific. If the government is intentionally avoiding its requirements to set aside 23% of the contracts, and those are goals, for small businesses by taking certain actions, that's something that could certainly be challenged. The facts of the underlying procurement would provide the basis for whether or not the government was intentionally avoiding its requirements, and you would have to look at that again on a case-by-case basis. But certainly, the government, and I know there's lots of different perspectives about it, but just based on my experience with the government very much wants to meet its small business set-aside goals. Now, they don't often understand fully how to do that, particularly when you're dealing with the hub zones. It becomes very confusing for a contracting officer, so they avoid that requirement as much as possible and try to meet their 23% other ways. But you could certainly look at anything with regards to that. And in a case like that, if the government were doing something like that, I would recommend that a contractor go back and utilize the agency level protest, which I do not like because I don't think, again, you get very good results. But in a case like that, you could say to the contracting officer, hey, look, this is what it looks like you're doing. We know you're supposed to set these aside, and you could probably do that very quickly and very inexpensively, dependent upon the facts in the case. Is that a fair answer?
Yeah, and then one other thing is, what's your experience? A lot of with similarly situated, a lot of construction companies with SBA passing the language for similarly situated, it's a great opportunity for these small businesses to team up to meet the performance requirements. However, it not being in the FAR, agencies have to do the class action waiver. Is this also something that, if companies are in a situation where agencies are not being receptive to the waiver, that they could, reach out to you and your organization to potentially get some help in that arena?
Absolutely. Certainly willing to work with folks on all those different issues. We deal with them on a regular basis. And, again, every one of these cases is really fact specific, and you got to evaluate it on a case-by-case basis. We certainly are always happy to talk to folks, and do kind of an initial consult. One of the things that I've always been most impressed about with our firm is we'll give you very candid and honest advice on whether or not we believe it's something that you should protest or something that you should pursue. We'll typically do that during the initial consult, and we don't charge for that. So we'll evaluate your case for free. We'll give you very, very candid advice, and we won't recommend that you pursue courses of action that aren't going to be beneficial to you or cost effective for you, particularly with our small business clients. We know that that's very, very important.
Well, that sounds good to me. So just letting you know, all the construction companies that are on the line, when you have questions, that's exactly who I'm referring you to. So I really appreciate you guys doing this, and I learned a lot. I don't know about anybody else, but I enjoyed it. So, thank you.
All right, well, thanks, and we'll listen in at 2 o'clock for the call. And everybody, the handouts and Tim's sheet on protests are available in the handout section on your screen, and we'll also be sending an email out to those who signed up with a link to download the documents as well. So. Thank you again, everybody, and look forward to hearing from you and meeting some of you soon. Bye.